Alright, year 2023 Maryland Statutes Environmental Title 14 Gas and Oil Subtitle 1 General Section 14101 Legislative Findings. General Assembly found with the declare of the production and development of oil and gas reach for the promotion of the economic oil building and state of the nature for the environmental drilling production of the oil and gas should be deducted of the manner that will minimize the effects of surrounding environment and improve the more proper evaluation of the project give the most environmental sign drilling production method necessary to prevent adverse environmental consequences of the detriment of the general welfare, health, safety, property, interest of the citizens of the state of the addition with certain circumstances of the oil and gas exploration production should be prohibited simply if the operations consider adverse effects of the environment in general of the assembly. For the deduct the exploration, production, oil, gas, or resources of subtitle will allow the safe utilization of state's natural resources that will provide with protection of state environment. Section 14102, definition of the subtitle of the following words have the means in K, coal bed methane, methane, with any other gas substance occurring with the producing of coal seam with the related associated with adjacent rock materials. County includes Baltimore and City unless otherwise indicated with the Department of Environmental Field means of the general area of the underlaid one or more pools. Fund means of the oil and gas fund. Gas means of the natural gas or other fluid. Hydrocarbon is defined as oil below is produced with the natural reservoir. Oil means with the crude petroleum oil. Hydrocarbons, regardless of the gravity which produced the wellhead with the liquid form, except for the liquid hydrocarbon known as distillated, consolidated, recovered, or extracted from gas. I, with the owner, means with the person who, with the right, with the drill, produced the pool, with the tour of the pool, with the appropriate oil and gas of the person, produced the tour of the eve of the person and the others. J, with the person provides the individual corporation, association, partnership, to receive with the trustee, with the execute, with the administrator, with the guardian, with the fiduciary, with the other representative, any of the kind. K, with the pool, underground reservoir contained with the accumulation, oil, gas, both. L, the producer, means with the owner, well, with the capable of producing oil, gas, or both. B, M, means with the product, with the commodity produced with the natural state by oil or gas well, with the N, with the production, means end with the process of the oil, brass from the natural reservoir production does not include the tail of the distribution of oil, gas, some of the underground storage, means with the storage of the gas over the geological shelf of the beneath the surface of the earth, tube of the underground storage. Includes injection gas, oil well, withdrawal of the underground storage reservoir with any other operation necessary convenient with the storage gas or oil of the underground storage or reserve of the mean with the shroud of the subsurface of the area with the end or used to end with the connection with the underground storage of gas and oil. Section 14103, authority of the Department to adopt rules and regulations. The Department may enforce effective the provisions subtitle of the adoption and promulgation of the rules and regulations. The Department may operate with limit of the output with the aim of the gas or oil well. Section 14104, drilling well with the disposing of the well product permit require environmental assessment. A, with the person may not drill with a well and with the exploration, production, underground storage, gas, oil, well, stay with the obtained with the permit with the Department of Environmental determined condition forms of the Department describes. B, the Department shall require with the applicable submit with the environmental assessment purpose of the evaluating with the application to be due with the Department shall coordinate with the Department of Natural Resource Evaluation Environmental Assessment. C, permits shall serve the permits required with the Division Title 9, Subtitle 13 article dealing with the well and the drill of the person made to dispose of the production, gas, oil without necessary permits issued with the Department. Section 14105, the drilling well and the disposing of the well production application of the permit. A, the application of the permit was drilled with the well to Section 14104 of the subtitle shall submit with the application made with the satisfaction of the Department. 2, for the application of the permit to drill well under Section 14104 of the subtitle, each application of the permit renewal shall include with the closure cost of the estimate of the proper sealing plug with the oil, gas well, the reclamation of the site with the Department shall establish collective fees. Issuance drill under Section 14104 of the subtitle, renewal of the permit to drill well under Section 14104 of the subtitle with the 3 of the production of oil, gas installed after October 1st, 2010. 2, the fees imposed by the subsection B shall be set with the Department by the rate of necessary for the implement for the purpose set forth in 14-123 of the subtitle of the official year with official fees established for the Department generates revenue with exceeded the amount necessary to appropriate regulatory program oversee with the drilling oil, gas well of the Department shall reduce the fees of the following fiscal year with the fees collected with the Department under the section shall be deposed for the oil gas fund established under Section 14-122 of the subtitle. And the Department shall provide public notice, public informational hearings, judicial review in accordance with the provisions Section 5204 of this article. Section 14106, with the drilling well, the disposing of oil, production, purification, profit. The Department shall verify application for the drill of the oil, gas well, with the drilling of the conduct of the geological formation not yet proved to be productive. If the Department verificates of the permit process of the issue for the permit of the exploration, only the production may not recommend for the environmental assessment required within Statute 14104 with the subtitle that has been completed with approved of the Department shall be the issue for the permit production. Additional opportunity of the public hearing shall be provided with accordance with 14105 the subtitle after the subtitle prior to the issuing with any of the permanent production. If the Department verificates of the permit profit environmental assessment required in Section 14104, this subtitle will be verified to address the separately environmental issue associated with the exploration production. However, in prior to granting mining permit conducting exploratory drilling with the coastal plain with the department shall require that the applicant such submit the environmental assessment with the contain with the general information regarding the environmental impact of the possible production, including potential effects of the efforts of the transportation, soil, oil, gas, and potential adversely environmental impacts may derive from the environmental characteristics of the drilling site. Section 14.107 the drilling well, the disposing of the well product, Chesapeake Bay, tributaries, and Bay critical area. The notwithstanding other level, the person may not drill or gas in the water of the Chesapeake Bay, any of the tributary of the Chesapeake Bay critical area. Section 14.107 hydrofracturing prohibited. In this section, hydrofracturing means the stimulating treatment of performed in oil, gas, natural gas, low permittable oil, and natural gas reservoirs through which specifically engineered fluids are pumped into the high-pressure rate with the reservoir interval of the tree with the causing fractures to open. A person may not engage with hydrofracturing as well with the exploration, production, oil, gas necessary in this state. Section 14.108 drill well, disposing of the wells, denial of the permit. The department shall deny of the permit determines if the proposed of the violate the requirements of subtitle regulation adopting with the subtitle of the proposed drilling well operation and proposes substantial threat, public safety risks, even adverse environmental impacts not limited to the following: Chesapeake area, Chesapeake Bay, critical area titled non-wet loans, endangered and threatened species with the conservation habitat, any of them. Historic properties are in section Title 5A2326 of the State Financial Procurement Article for populated area fishery, water, estuary, and marine fisheries, other significant natural resource. With the application failed with the receive the applicable permits approval of the operation of state and local regulatory units responsible for the air and water pollution sediment control and zone with the operation constitute the significant political head of the neighboring dwelling of the school, of the church, of the hospital, commercial, industrial building, public road, other public and private property with the existence of the time of the application of the permit. The operation will significantly adverse effect the use of the public-owned park, forest, recreation, in an existing time of the application of the permit. If the application is not corrected with any of the violation committed with the application under any of the prior permit. Section 14.109 seismic operation permit required use of explosive within the section of the following words means indicate with explosive mean with the normal commercial explosive with the blasting age of the detonator seismic operations mean control the application vibratory energy with the source of the determined variable condition with the subsurface extraction of the oil and gas. Seismic section means the geographic natural near vertical display with a waveform of the data of the unusually processed by the computer program facilitated with the interpretation subsurface conditions. B. Unless of the person obtains a permit with the department, a person may not conduct seismic operations. The date of the application with the conduct of the permit is seismic operations shall submit with the application include with the information required by the department. 3. In addition, any of the information from the department and the applicant with the permit to conduct with the seismic operation water of the Chesapeake Bay, the navigable tributary with the provider with the department a written agreement to submit with the department to process the seismic section with the operation conduct with the waters of the Chesapeake Bay with the navigable tributes. 3. The department shall hold process seismic sections submitted within subsection confidentially. 4. The department shall determine the term and condition issued with the permits for the conduct of seismic operations. 5. The application of the permit for the conduct of seismic operation demonstrated the evidence of sufficient liability. The insurance cover the amount with the determinant for the department of personal injury for the property damage result of the seismic operation. 6. The department may deny the application permit if 1. The application does not submit the information required by the department. 2. The proposed activities poses a substantial risk of the causing environmental damage that cannot be mitigated with the application, particularly with the Chesapeake Bay. The Chesapeake Bay critical area, the non-tidal wetline when endangered, certain species with the habitats in the species designated the archaeological site of the populated area. 3. The proposed operation violate with the regulations adopted by the department in accordance with this section. 7. The department decide with the denial of the permanent notification denial shall state with the reason for the modification necessary for the proof of the application of the rights of the applicant to appeal with the decision provided with the Title 10 Subtitle 2 of the State Government Article. The person may not use explosive for the seismic operation conducted the water of the Chesapeake Bay and its tributary. The person may use explosives in seismic operation conducted on land if the person complies with the requirements to use the explosive established by the department. Section 14.110 conditions of the permit. A permit shall be expressly continued in compliance with the requirements of the subtitle, any of the regulations adopted in the subtitle. The permit shall play for the permit condition with the department deems reasonable and appropriate for the issue. They should fully comply with the requirements of the subtitle provided with the public safety and with the protection of state natural resources. And B. Violation, permit condition, violation, subtitle, subject to enforcement penalties under this subtitle. Section 110.1 Presumptive impact areas around gas. In this section, water supply means of the source of the water for the drinking, with the other domestic purpose for the agricultural investing, including livestock, for each of the permit with the department issuing under the subtitle of the drill with the exploitation production of the gas, deep shell with the deposit for the presumptive impact around with the gas well with the presumed with the contamination, water supply with the cover the active with the gas exploration production, presumptive impact area with effect with the radius of 2,500 feet with a vertical well bore, 365 days the last event of well drilling with completion, hydrofracturing with the presumptive impact established in the subsection B and C of the section permit shall be replaced with no expense for the owner and operator of real property presumptive the impact area of the water supply contaminated result of the permit drilling and operation of the gas well. Either the water supply within the presumptive the impact area of the not longer yield potable water result of the drilling and operation of the gas well consider the replaced with the adequately permitted with the permit that provides for the effective of the property owner of the new or retrofitted well with the other alternative water supply capable of yielding potable water equal to the volume needed for the property owner to perform contamination water supply with the permit of the property owner may agree with the monetary compensation or other mitigation instead of restoration. Chief of the department may not require the permit to replace the water supply with the compensation of the prior owner is provided with the section permit with the demonstration of the department of preponderance for the evidence of the contamination and not result of the activities relating with the gas well with the contamination existed with the commencement of the activities allowed with the permit and was not worsened of those activities. The department may adopt the regulation of the implementation section presumption causation establishment of the section does not apply with the contamination water if one of the permit application requires for the permission of the property owner sample to test the water supply before the commencement of activity provided with the property owner with a complete copy of the test result of the property owner refuse the permission of the J which may be contributed with effect for the common law remedy that is available to the property owner. K with the presumption of causation established for the section shall apply with the seeing additional review of section 114.117 subtitle action with the injunction 114.118 subtitle within 3 a civil action with the damages equitable relief brought property owner against the permit and 2 the presumption may be rebutted in preponderance of the evidence. Section 14.111 duties of permittees except for the providing the subtitle subsection D with this section of the every holder of the permit of the drill for gas or oil shall 1. Submit the completion of the report on the form supplied by the department in 30 days for the drilling of the water as completed. 2. For the submit the cutting sample the request for the department. 3. Notify the department when the well is to be abandoned. 4. Comply with all the requirements. Subtitle include with the proper scheme of the plugging the gas or oil well with the reclamation of the site. 5. Provide financial assurance with at least $50,000 each gas or oil well that included each of the multi-well pads not less than the most recent closure of the cost estimate provided to the permit holder of the section 14.105A of the subtitle of the table to keep it in effect with the comprehensive general liability insurance coverage amount not less than $300,000 for each person, $500,000 each occurring with the accident with the pay damage for the incurred with the person, damage for the property cover the sedition accidental occurrence of the arising from the performance reporting activities are authorized by a permit issued within section 14.104 of the subtitle, including the cost expense for the incurred in the investigation, defense, and settlement claims obtained to keep it in effective environmental pollution liability insurance amount not less than $1 million per for the bodily injury, property damage of the person, the natural resource of the development damage, including cost cleanup of the remediation, cause sudden of the non-sudden release of pollutants arising in support of the activities authorized or permit with the issue in section 14.104 with the subtitle, who the cost expense for the incurred with the investigation, defense, and settlement claims in 8 the event of the assignment with the transfer maintained with the existing financial assurance required under the section and requirements of the financial assurance that approve the department and notify the department the location and equivalent required for the regulation, prevention, contamination, gas, and oil leaks. B. Environmental population, pollution, and liability required within the subsection A7 in the section shall be maintained in 5 years of the department to determine when the gas or oil has been properly sealed or plugged with the site has been reclaimed. C. With this permanent holder financial assurance required in subsection A and B of this section shall 1. Extend with the owner and owner of surface and subsurface of the properties. 2. Cover the acts and mission of the permit holder, contractor, subcontractor during their activities in connection with the drilling operation closure of the well. D. The accept of the provided in paragraph 2 of the section of the holder of the permit for the drill and oil gas as well existing on or before October 1st, 2013 shall provide financial assurance for the maintaining such surface bond and for the liability insurance of the required for the hold for most permanent or recent permanent renewal issued on before October 1st, 2013. If gas or oil existence on or before October 1st, 2013, modified after October 1st, 2013 by the recompletion of the simulation for the deepening and adding lateral extension of the holder of the permanent gas or oil well to comply with the requirements of financial assurance contained in subsection A, B, C, and E. The department may adopt the regulation, increase the minimum amounts of financial assurance required in subsection A of the section, and enable the permit application for the department to authorize alternative means of the demonstrate financial incurrence, including performance bond, blanket bond, cash, certificate of deposit, letter of credit, self-assurance, corporate guarantee, any other surety of the determined it's a good and insufficient. 3. Establish alternative financial assurance requirements appropriate with the new gas storage well when the gas storage is modified with completion and recompletion, stimulation, deepening, and adding lateral extension. Further, the department shall adopt regulations requiring each holder of the permit to drill and oil, gas, have the equipment available to prevention contamination with the gas leak and oil spill. The permanent transfer of the permit may become effective if the financial assurance requirements of the section has been satisfied. Alright, 14.112 location of wells, except for the provided in paragraph 2 of the section of the well protection underground storage gas oil that may not be drilled prior to near the 1,005 of the boundary property line of the agreement over the owner and the gas and oil adjacent lands. Through the well production, coal bed methane may not be drilled on the property nearer than 500 feet of the boundary property, with except with agreement with the owner of the coal bed methane adjacent lands. B. On property where it is impossible to locate with the well required with a minimum distance of the boundary with no agreement of the owner of the gas, oil, coal, bed, methane adjacent lands may have been made. A well may be located near the required minimum distance. Subsection A of the section of the boundary well with the consent of the department. However, when any of the permitted to drill well near the required minimum distance, the boundary has been applied with the department shall notify the landowner, royalty owners, leaseholder within the required minimum distance location proposed well, give them a reasonable opportunity to fill the objections of the issuance of the permit. The department shall hold a hearing. Permit determines if necessary for the well to be located near the required minimum distance of the boundary. It may issue the permit with the required landowner, royalty owner, leaseholder with the required minimum distance of the proposed well has the right to rehearing appeal of the course provided in subtitle. Request for the rehearing or an appeal to the court stays with the authority granted under the permit over the final determination issue of the permit is made. See the department rule regulations will prescribe the distance between any two wells of any property. Or Section 14.113 payment of royalties when the leased land is included under a unit agreement. On completion of the well producing the gas oil of the leased land is included under the unit operation agreement, of royalty for the production of well shall be paid on lands originally included with the unit operation agreement within 6 months of the completion of the producing of the lines. Even the operation agreement is not included in a pool of the acreage, but with no royalties payable shall be released unless the owner of the land has otherwise agreed in writing. The section does not extend to any lease of the unit operation agreement in effect with June 1st, 1956. Section 14.114 Rules Regulation Orders except the emergency rules regulation orders of the amendment, but may not be made with the department without public hearing with at least 10 days. Note that the public hearing should be held at the time and the place prescribed with the department. Interested person entitled to be heard by the department. B. The emergency requiring immediate action exists if the department authorized to issue the emergency order. The written notice of the emergency order takes effect with the promulgation. Emergency order may not remain effective for more than 15 days. See all rule, regulation, orders issued for the department shall be written into the index book for the captive of the department and public documents for the inspection during the normal office hours. Accompanying with the rule regulations others certified by the secretary of the department, the secretary designing of the receive the evidence and all of the courts the same effect with the original of the department and effect the of the other motion of the position and interest of the person. When filing of the position concerning the matter of the jurisdiction properly fixes the hearing, causing the notice of the hearing to be given, the hearing shall be properly afforded filing of the position hearing and relates to the issue of the permit for the respect with the specific well held with the county or the municipal corporation wherever the law is located. Permit shall enter within order of the 10 days after the hearing. Section 115 Subpoena. The department may summon the witness for the administrator over the required production of the record and books and documents of the examination of the hearing and investigation conducts. If the person failed to refuse to comply with the subpoena issued by the department, if any would have refused the test any of the man regarding the witness, sincerity gave of the court of the competent jurisdiction upon the application of the department, may issue the attachment of the person compelled for the person to comply with the subpoena with the appeared before the department produce for the record of documents, examination, give the testimony, the person to disobey with the subpoena, and refuse to testify with the court may punish the person for contempt. Section 14.116 rehearings for a person adversely affected with the rule regulation order of the department. Any person adversely affected with the rule regulation termination order of the department may within 15 days of the effective the day of the file with the department in writing of the rehearing. Application shall be acted upon within 15 days after its filing. The rehearing is granted shall be held promptly. Section 14.117 appeal of the department decisions except as provided in section 14.105 of the subtitle with any perfect agree with the action of the department that may apply with the circuit court of the county which the person resides at the well is located with the review of the decision. Any other interested party may intervene with the department and may become party of the to the appeal of the case shall be documented at once for the may be taken in precedence any other civil cause of the action proceeding on the docket. Court shall hear of the proceeding of the deed and over determine all the manner of the law fact without the jury rendering its decision, proving the setting of the side of the modifying with the department's actions. Any party agreeing with the final decision of the court may appeal for the courts of special appeals. 118 Injunctions. Upon application for the department verified oath of affirmation for the circuit court of the county whether as well is located sitting in the equity may be the injunction and enforce the compliance with the restraint violation any order notice of the rule regulation made under the provision of subtitle restraining with the violation attempted violation other than any of the provision of the subtitle. Section 119, gas to be metered. Any person who owns property with a gas well will not willfully take gas within the life of the gas if the meter with the chain of gas meter with the cleaning of the blowing of the well is not constructed and taken within the meaning of the section, and any person with the operating producer of the gas is well violated the term in this section. Person or operator interest of the lease under which the well is produced shall be voided with the subject of the cancellation suits of the owners of the world interest in land premises of the premises. Violation occurred. The department shall inspect the read of the test any meter through of the natural gas being measured upon the request of the leaser, lesser, operator, royalty owner of the lands who the leases or royalty interest in natural gas is being produced. 120 penalties. For each offense of the person violated for the provision, subtitle of the guilty of the misdemeanor of the conviction of the competent jurisdiction subject to a fine of $50,000 amount of the addition with the cost damage result of the cause of the permit to include the contractor permitting any oil, gas leak, any of the discharge, any violation of subtitle costs imposed with the discretion of the court, any penalty imposed with the subtitle, in addition to any other penalty provided by law. Section 14-121, inspection coal bed methane production. The department may make inspections determined necessary for the ensure the compliance with the subtitle in order to carry out the inspection according with the section. The department, the authorized agents may, one, conduct testing, sampling, examine the book, paper, the records of the relate any matter under any of the investigation according with the subtitle without reasonable times, enter and examine any property, facility, operation, activity. Section 14-122, oil gas fund. This is the oil gas fund. The fund consists of the fees collected by the department in section 14-105 of the subtitle funds appropriated to the general and some of the deposits of the fund. 3 fines are perceived with the final insurance for the instruments of the collected by the department in accordance with this subtitle will exceed the amount of the necessary reclaim a site for an additional money with the made available to the store of the public and private. The purpose of the fund has established a fund special for the non-lapsing fund that does not subject to statute 7302 with the state financial procurement article. Nothing been installed in this law, nothing withstanding any law of the country, unused money of the fund, and not to retrovert in the general fund. The fund maintained and administered by the department in accordance with the provisions of the subtitle and any regulation the department adopts. Section 114-123, use of money. The department shall use the money funneled solely with the administer implement program that oversee with the drilling, with the development, production, storage, oil, gas well, with the other requirements related with the drilling and oil, gas wells. Include all costs incurred with the state of the review, the inspect, with evaluating, monitoring, data, application, license, permit, the analysis of the report, with the performing, oversee with assessment, investigation, research, the the permit, inspection, compliance activities, and develop, adopt, and implementation regulation programs that initiative with the address risk of the public safety, human and health, the environmental related drilling, development, oil, gas wells, including method of hydrofracturing. Section 114-124, reporting. Before beginning November 1st, 2010, the department shall report each year with the general assembly in accordance with Section 212-57 of the state government article on the status of the fund, revenues, oil expenditures from the fund, and the efficiency of the regulatory program under the subtitle of the compliancy rates for the regulatory program under the subtitle of the 5 of the based on the fact listed to items 1 through 4 of the section necessity to review them and adjust the fees in accordance with Section 14-105 of the D of the subtitle. 125 regulation. The department shall adopt regulation to carry out the subtitle of the tablet's procedure for the imposing the collecting fee for the tablets in accordance with Section 14-105 of the subtitle. And that was subtitle 1 in general title oil, gas and oil, Maryland statutes, environment.